3 states, 1 playbook, and they all sold it the exact same way. We're not banning your handgun, we're banning Glock switches.
But here in New York, we don't wait. We lead.
They told you one thing on the news and wrote something completely different into the law.
So let's get AR-style guns banned. And then all they do is keep getting another model and another model and another model until every gun imaginable is listed on the addendum. So effectively the bill is what? A gun ban.
Just ban the Glock. Not the switch, like the Glock, the gun. The handgun sitting in most cop holsters in this country.
It's a shame, you know? It's such a good, reliable pistol.
New York state budget just made the most popular handgun in America illegal to buy. Governor Kathy Hochul signed Chapter 55 of the laws of 2026 into law, embedding a sweeping firearms provision within a massive multi-billion-dollar state budget framework. The bill is officially labeled a public protection budget measure, a title designed to project administrative necessity and broad public safety goals. What it does in reality is create a brand new, highly restrictive legal category in the New York Penal Code. That category is defined as a convertible pistol, and it systematically eliminates the commercial sale, transfer, and importation of that entire category in 2 devastating stages. The enforcement timeline for this legislation is already running, and the clock is ticking down rapidly for gun shops and gun owners across the Empire State. August 25, 2026 is the first critical date on this legislative calendar. May 31, 2027 is the second, final enforcement date. Because this major firearm ban was hidden deep inside thousands of pages of complex state budget appropriations, most of the everyday citizens and gun owners this law directly affects do not even know either date exists yet. They are completely unaware that their standard self-defense setups are facing a massive structural shift under state law. Here's what most mainstream media coverage is getting completely wrong about this developing situation. This law does not simply ban illegal auto-sears, commonly referred to as Glock switches. New York State already criminalized the possession of those illegal conversion devices years ago, matching strict federal statutes enforced by the Bureau of Alcohol, Tobacco, Firearms, and Explosives. What this new budget law explicitly bans is the unmodified, completely stock firearm itself. Specifically, the text outlaws any semi-automatic pistol featuring a cruciform trigger bar that can accept a mechanical converter. When you study the mechanical reality of modern firearms engineering, you realize how extraordinarily wide that net is cast. That technical definition directly covers the Glock 17. It covers the Glock 19. It covers the Sig Sauer P320, the Smith & Wesson M&P series, and the Springfield Armory Hellcat. These are not specialty, niche, or fringe products designed for tactical operations. These are the single most common, reliable, and widely purchased handguns sold in the United States for civilian home defense and personal protection. Together, they represent the overwhelming majority of lawful handgun sales in the state of New York every single year. Under this newly signed budget bill, all of them are now legally defined as an inherent problem that must be cleared from the commercial market. To understand the sheer scale of this restriction, you have to look at the market dominance of striker-fired polymer frame handguns. Glock-patterned striker-fired pistols are standard issue at more than 65% of major law enforcement agencies in the United States, including elite state police units and local police departments. They are chosen by professionals for the exact same reasons they are chosen by law-abiding civilians. Their absolute reliability, simplicity of operation, ease of maintenance, and affordable price point. The United States Supreme Court's landmark 2022 Bruen ruling established a clear constitutional boundary. It stated that individual states cannot ban or heavily restrict firearms that are in common use by law-abiding citizens for lawful purposes like self-defense. That common use test is the absolute controlling standard in every single federal Second Amendment case being litigated across the country right now. Yet New York's new convertible pistol law targets the exact mechanical category of firearms that best fits the Supreme Court's common use definition. Consider the raw data behind these numbers. Glock alone has manufactured and sold over 20 million pistols into the American market since they first arrived on U.S. soil in 1986. If you factor in other major manufacturers utilizing functionally identical striker-fired operating systems, conservative estimates of total ownership in civilian hands run deep into the tens of millions. The Supreme Court in the Bruen decision did not establish a specific rigid numerical threshold to define what constitutes common use. However, the justices explicitly cited modern handguns as the paradigm example of a weapon in common use for self-defense. any legal defense mounted by the state of New York arguing that Glock-style handguns fail the common-use test runs directly into a brick wall of the Supreme Court's own binding language in both Heller and Bruen. To see how this law plays out on the ground, we have to look closely at the mechanics of the two distinct enforcement dates. On August 25, 2026, New York law enforcement and prosecutors will begin implementing the first phase of Chapter 55. Starting on this date, the state will treat any convertible pistol that has an illegal converter device attached to it as a fully automatic machine gun under state penal law. As stated, the mechanical converter itself has been completely illegal in New York for years. But after August 25th, combining a lawfully possessed standard striker-fired handgun with an illicit converter does not just result in a standard possession charge for the illegal device. It fundamentally reclassifies the host firearm itself as a machine gun in the eyes of the law. Machine gun possession charges carry substantially heavier, mandatory minimum prison sentences and felonies compared to a standalone converter violation. If you own a Glock-style handgun within New York, and an illegal converter device is found by law enforcement in the exact same location, your criminal exposure and your legal position shift dramatically on August 25th. That is because prosecutors will have the statutory authority to charge you with possessing an actual machine gun. Then comes the second, more permanent hammer blow. On May 31st, 2027, the commercial sales ban takes full effect across the state. After this date, any licensed firearms dealer, gunsmith, or commercial retailer who sells, transfers, leases, or ships a convertible pistol anywhere within the borders of New York is committing a Class D felony. Under New York sentencing guidelines, a Class D felony carries a penalty of up to 7 years in state prison. Local gun shops selling striker-fired polymer handguns, which describes virtually every single mom-and-pop gun store and major outdoor retailer operating in New York, now have a narrow 12-month window to clear their shelves. If they do not, their standard commercial inventory creates direct felony exposure under state law. The legislative process that produced this sweeping ban is just as critical to analyze as the text of the law itself. The New York State Constitution contains a clear mandate requiring that state budget bills must strictly address fiscal and appropriations matters, inserting a highly controversial, sweeping criminal gun ban into thousands of pages of dense appropriations. Language completely destroys the normal, transparent legislative process. By executing this move inside a budget bill, lawmakers entirely bypass standalone committee hearings dedicated to the gun provisions. There was no separate dedicated window for public testimony where gun owners or industry experts could voice concerns. There was no distinct, isolated floor vote on the firearms language itself. The New York Senate passed the full massive budget package by a vote of 39 to 22. The state assembly passed it by a vote of 93 to 47. Every single legislator who voted in favor of this gun ban did so because it was permanently tethered to the exact same omnibus spending package that funded local public schools, public hospitals, infrastructure repair, and affordable housing programs. For lawmakers on the fence, opposing the extreme gun control language meant voting down the entire state budget and shutting down the government. National gun rights organizations are labeling this tactical maneuver the budget ambush model. The National Rifle Association's Institute for Legislative Action has formally flagged this development as a highly dangerous legislative strategy. They expect to see anti-gun lawmakers replicate it in blue states across the country, because it successfully shields controversial gun control measures from public scrutiny and individual floor votes. Gun rights groups warn that at least 3 other state legislatures are currently actively studying the New York approach to deploy during their upcoming 2027 legislative sessions. While the inevitable constitutional challenge has not yet been formally filed in New York federal courts, the exact legal blueprint for the coming war already exists out west. When California enacted its own nearly identical version of a convertible pistol ban, a powerful coalition of civil rights groups filed a major lawsuit titled James v. Bonta in the United States District Court for the Southern District of California within just 72 hours of the bill being signed. The plaintiffs in that landmark case represent a unified front: the National Rifle Association, the Firearms Policy Coalition, the Second Amendment Foundation, a California-based retail firearms dealer, and 2 individual law-abiding gun owners. The central foundational argument in James v. Bonta is simple. The state cannot ban an entire class of handguns that are overwhelmingly chosen by millions of citizens for self-defense, meaning the law is unconstitutional on its face under Bruen scrutiny. That exact same legal argument applies directly to New York's version. The targeted mechanical category of firearms is completely identical in both states. The only variables are the precise statutory wording in the penal codes and which specific federal circuit court handles the initial appellate ruling. As of right now, 4 states have successfully placed convertible pistol bans on their books: New York, California, Maryland, and Connecticut. Each of these state laws uses slightly different legal definitions and phrasing, but all 4 target the exact same fundamental, striker-fired design that utilizes a cruciform-style internal trigger bar. All 4 jurisdictions are now functioning as high-stakes test cases for one single overarching constitutional question. Can a state government ban the commercial sale of a perfectly safe, commonly owned firearm simply on the theoretical grounds that it is susceptible to an outside, unlawful criminal modification? Can they do this even when that exact firearm happens to be the most widely purchased defensive handgun in modern American history? Under a faithful application of the Supreme Court's Bruen historical tradition test, the answer to that question appears to be a definitive no, yet these 4 states are actively asserting otherwise, using their state power to dry up commercial markets. A federal circuit court is going to have to step in and decide which interpretation of the United States Constitution is correct. For law-abiding gun owners currently residing inside New York, it is crucial to understand your exact legal position as it stands right now. The possession and carry of an existing lawfully acquired Glock pattern or striker-fired handgun remains fully legal within the state. This budget bill did not create a retroactive confiscation order, nor did it establish a mandatory state registry for pistols you already own. The total ban on commercial retail sales does not take effect for another 12 months, in May of 2027. However, the first critical date of August 25, 2026 is rapidly approaching. At this moment, no federal judge has issued an injunction or a temporary restraining order to pause or stay that fast approaching enforcement date. If you happen to own a convertible pistol within New York and an illicit conversion device is found within that same immediate physical space, the automatic machine gun reclassification will apply directly to you under the letter of the law. The practical steps available for New York gun owners are limited but highly urgent given the timeline. Ensuring that your legally owned firearms and any potentially regulated items are kept in entirely separate physical locations is a critical boundary to understand. This is essential to avoid triggering the combined machine gun reclassification status. Furthermore, verifying whether your specific personal protection pistol models fall squarely under the state's cruciform trigger bar definition is an essential step to complete before the August deadline. The New York State Association of Chiefs of Police has already published a detailed administrative summary of Chapter 55. It provides local law enforcement with guidelines on exactly what models and mechanical configurations the new convertible pistol definition is intended to capture in practice on the street. National and state gun rights organizations are tracking the litigation timeline around the clock, preparing to file for immediate emergency injunctions to halt the implementation of the law before the August timeline hits. If the United States Court of Appeals for the Second Circuit upholds New York's budget law, while the United States Court of Appeals for the Ninth Circuit strikes down California's version in James v. Bonta, the legal system will face a massive federal circuit split. A direct circuit split on a question as massive as whether the most popular handgun design in modern American history can be banned at the state level is the exact type of high-profile constitutional conflict that the United States Supreme Court is structurally designed to take. That final showdown in Washington, D.C. is exactly where all 4 of these state-level bans are ultimately heading. How quickly federal district judges choose to act to protect consumers. What happens to retail inventories as the deadlines loom, and how these laws will face their very first major test when they reach a federal circuit court is right here.